Let's start. The appellant oblique state of Odisha has filed this appeal assailing the order of the High Court of Odisha dated 13/11/2009, passed in second appeal number 98/1993, where under second appeal filed by the appellant herein came to be dismissed, and consequently the judgment and decree passed in favor of the respondents by the first appellate court in TA number 2/100 of 1992 to 1991 came to be affirmed. The suit property being a Khasmohol measuring 594 declaims situated in plot bearing number 894 Kata number 158 Balukant Puri was originally leased in favor of one Shoilendranath Mitra within bracket herein after referred to as original lessee for 30 years commencing from 29/09/1905, and said the lease was due to expire on 29/09/1935 on 16/10/1935. The original lessee applied for renewal of the lease, which came to be referred as the lease renewal case number 40/1935-36 para. Above being the situation, the original lessee expired on 04/06/1941, leaving behind his two sons, Nolinath Mitra, Jyotindranath Mitra, within bracket father of the plaintiffs, his wife Khagendrabala Mitra, and his daughter-in-law Srimati Gauribala Mitra as his legal heirs. A substitution petition came to be filed by the legal heirs of original lessee in case number 40/1935-36, and subsequently on 22/01/1944 the lease came to be renewed and a fresh lease came to be executed in favor of the legal heirs of the original lessee for a further period of 30 years. Of the legal heirs of the legal original lessee expired on 25/09/1965 para. On 23/12/1972, late Nolinath Mitra within bracket one of the lessee preferred an application for renewal of the lease in lease renewal case number 11/1972. The renewal officer Puri Odisha directed the case records to be forwarded to Tehsildar Puri for inquiry and report pursuant to the order of the revenue officer. The Tehsildar, after conducting file verification, submitted a report on 30/05/1975 to the collector Puri, indicating that the structures over the shoot property are dilapidated and that outsiders have occupied the house, and consequently the Tehsildar suggested for the intimation of resumption proceedings. Para. Pursuant to the same, value resumption case number 6/1975 came to be registered by order dated 21/08/1975. The collector Puri, after considering the report of the Tehsildar, determined the lease by observing that the lessee had violated the terms of the lease agreement under clause 9 and 20 as prescribed under the Bihar and Odisha Government States Manual 1919, and directed the lease to surrender the leasehold land with 30 days from the date of notice. Para. Accordingly, notice came to be issued to the lessee Nolinath Mitra on 22/08/1975, directing him to surrender the leasehold land after removing the structures within 30 days from the date of notice, failing which the Tehsildar would re-enter and take possession. Subsequently, the collector, after visiting the site and noting that the building is in utter state of disrepair, passed an order on 17/09/1976 in value resumption case number 6/1975, directing the Tehsildar Puri to take physical possession of the land and remove the standing structures. On 24/09/1976, the Tehsildar took over the physical possession of the leasehold land along with the building. Para. In the aforesaid factual scenario, the plaintiffs oblique respondents herein, that is legal heirs of Jyotindranath Mitra within bracket another son of original lessee, filed a suit for declaration and permanent injunction in OS number 161/402/290/86, playing for declaration that the order of the collector dated 21/08/1975 in resumption case number 6/1975 as illegal, without jurisdiction, and to direct the collector to renew the lease and pass a decree directing the defendant oblique appellant herein to execute and register a lease deed in respect of the suit property by way of renewal in favor of the plaintiffs, and to pass a decree of permanent injunction restraining the defendant from leasing out the suit property to others. It was the case of the plaintiffs that, being the legal heirs and successors of original lessee late Shailendranath Mitra, the lease had been renewed in their favor in 1944 for a period of 30 years commencing from 26/09/1935, and a suit for partition had been filed in suit number 1377/1967 before the Calcutta High Court, wherein a receiver came to be appointed in respect of the suit property who had applied for further renewal of the lease in respect of the suit land no action was taken by the defendant of the appellant hearing, and subsequently Nolini Mitro within bracket one of the lessees had also applied for renewal of a lease in the year 1972, and he had expired on 13/12/1975, and on 13/12/1975 advocate of late Nolini Mitro replied to a letter issued by Tehsildar by intimating the death of Nolini Mitro, and had prayed that the application for renewal filed by treated to have been made on behalf of Khagendra Bala Mitro and Jyotindranath Mitro, the mother of the brother of Nolini Mitro, respectively. In the partition suit, the suit properties were exclusively allotted to the share of the plaintiffs oblique respondents herein, filing decree dated 10/12/1973, and as such the plaintiffs had approached the authorities for the renewal of the lease in the year 1980, for which no reply was furnished to them. Further, when they made inquiries in 1983, they came to know that the defendant of the appellant had initiated suo motu proceedings in the year 1975, and without issuing notice to the plaintiffs, the lease had been determined on 21/08/1975. On the basis of these amendments, the plaintiff sought for decreeing the suit. Stop. Thank you.